Federal income tax law in a nutshell from losthorizons.com newsletter. Please don't judge me harshly. I've never read this 4-page complicated document, but I'm going to give you the gist of it. Federal income tax law in a nutshell. United States Supreme Court, South Pacific versus Lowe, 247 U.S. 300, 1918. We must reject the broad contention submitted in behalf of the government that all receipts, everything that comes in, are income. Morris Hubbard, Treasury Department Legislative Draftsman, House Congressional Record, March 27, 1943, page 2080. The income tax is an excise tax with respect to certain activities and privileges. That income is not the subject of the tax. Then why the 16th Amendment? It was passed to close a loophole created by the case of Pollock versus Farmers Loan and Trust, United States Supreme Court, 158 U.S. 601 in 1895. Mr. Pollock argued that federal stock he has purchased with his personal property and that taxing the federal dividends from the stock was equivalent to taxing personal property, which was an unapportionated direct tax prohibited under Article 1. The Supreme Court agreed and struck those particular sections from the code. The sole purpose of the 16th Amendment was to close the loophole and restore to Congress the power to tax federal dividends, even if those federal dividends were derived from personal property, hence the source derived language. However, most people are taught that the 16th Amendment gave the federal government new taxing powers, eliminating the protection offered by the Article 1 of the Constitution. This teaching is blatantly incorrect. The Supreme Court has clearly stated numerous times that the 16th Amendment gave Congress no new taxing power. United States Supreme Court, South Carolina versus Baker, 485 U.S. 505, 1988. The legislative history merely shows that the sole purpose of the 16th Amendment was to remove the apportionment requirement for which incomes were otherwise taxable. United States Supreme Court, Peck versus Lowe, 247, 1819. The 16th Amendment does not extend the taxing power to new or accepted subjects. United States Supreme Court, Stanton versus Baltic Mining Company, 240 U.S. 103, 1916. The provisions of the 16th Amendment conferred no new power of taxation. United States Court, Birch Bar versus Union Pacific, 240 U.S. 1, 1916. The confusion arises from the erroneous conclusion that the 16th Amendment provides for a hitherto unknown power of taxation. The contention that the amendment treats a tax on income is a direct tax, relieved from that apportionment, is wholly without foundation. The amendment demonstrates that no such purpose was intended, and on the contrary, shows that it was drawn with the object of maintaining the limitations of the Constitution. The amendment makes such wider significance a part of the Constitution, a condition which clearly demonstrates that the purpose was not to change the existing interpretation. Federal income tax law in a nutshell from losthorizons.com, nutshell. Newsletter, nutshell, in a pamphlet. The 16th Amendment was passed only to ensure that all federally privileged income could be taxed, regardless of the source from which the federal income was derived. Number 3. So making money or having money or being paid or receiving earnings or being a private sector employee in the normal sense of the word, as opposed to the limited term employee defined in the Internal Revenue Code, is not the subject of the 16th Amendment and is not the subject of the Internal Revenue Code. The Internal Revenue Code makes use of many legal terms, which have a different meaning than the common words they mimic. Whenever the IRC uses common terms like wages, employee, employment, and self-employment, those custom terms do not apply to all monies, workers, and occupations. They only apply to privileged, defined wages, employees, and employment that are subject to the income tax excise. The Internal Revenue Code further acknowledges this by explicitly not including private sector, meaning non-federally privileged monies, workers, or occupations in any of its custom definitions. Ordinary occupations of common right are not and never have been subject to the income tax law. Number 4. However, when a company submits a W-2 that lists an ordinary, non-privileged citizen as having received wages, for instance, those wages are assumed under the law to be federally privileged because that is the only purpose of a W-2. The company's erroneous testimony is the testimony of record until the citizen files his tax return. The tax return is the citizen's testimony, signed under penalty of perjury, that either agrees to or rebuts the company's testimony. Agreement is accomplished by properly filling out the tax return, attaching a copy of the W-2, and signing accordingly. Rebuttal is accomplished by properly filling out the tax return, attaching a rebutting affidavit, such as Form 4852, in lieu of the W-2, and signing accordingly. If the citizen does not file the employer's testimony, the employer's testimony stand, and the full weight of federal income tax law falls upon the citizen because he is presumed by law to be a taxpayer. This is why non-filers and zero filers who put zeros on returns but do not rebut the W-2, lose in court, resulting in mountains of lower court cases that make it look like everyone is liable for income tax. Because the protesting taxpayers never address the fundamental issues and requirements of the law in the form and manner prescribed. If the citizen has properly filed with the 4852 or some other proper instrument of rebuttal, and his earnings are not federally privileged, then for the federal income tax purposes, he is a non-taxpayer, and federal income tax law does not apply to him. United States Court of Claims, Economy, Plumbing, and Heating versus United States, 470 F2D 585 in 1972. The revenue laws are a code or system in regulation of tax assessment and collections. They relate to taxpayers and not to non-taxpayers. The latter are without their scope. Furthermore, if any monies have been withheld, the non-taxpayer is entitled by law to a full refund. Number 5. You want to write Congress about this? They already know, and they are willing to keep taking your money as long as you are willing to give it to them. Check out the testimony of congressional attorney as recently as 1979, Howard Zadinsky, legislative attorney, Library of Congress, Report 80-19A, 1979. The Supreme Court has noted that the 16th Amendment did not authorize any new type of tax, nor did it repeal or revoke the tax clauses of Article 1 of the Constitution. Direct taxes are, notwithstanding the advent of the 16th Amendment, still subject to the rule of apportionment. These same principles extend to payroll taxes, i.e., Social Security and Medicare. Over the last 5 years, thousands of citizens who understand the law have received full refunds of income and payroll taxes, resulting in millions of dollars being returned to their rightful owners. For evidence and more details, see losthorizons.com. And the last page on federal income tax law in a nutshell from Lost Horizons. The United States Constitution forbids direct federal taxes and is the only item in the Constitution that is stated twice. Again, the United States Constitution forbids direct federal taxes and is the only item in the Constitution that is stated twice. Article 1, Section 2. Direct taxes shall be apportioned among the several states. Article 1, Section 9. No capitation or other direct tax shall be laid unless in proportion to the census. Direct taxes are taxes on a person's property, or the exercise of a fundamental right. Any tax on a person's labor or on their earnings from their labor is a direct tax. United States Supreme Court, Knowlton versus Moore, 178 U.S. 41, 1900. Direct taxes bear immediately upon persons, upon the possession and enjoyment of rights. United States Supreme Court, Butcher Union Corporation versus Crescent City Corporation, 111 U.S. 746, 1883. The right to follow any of the common occupations of life is an inalienable right. United States Supreme Court, Kopech versus Kansas, 236 U.S. 1, 1915. Included in the right of personal liberty and the right of private property is that of personal employment, by which labor and other services are exchanged for monies or other forms of property. Apportioned and in proportion to the census means that the tax is billed to the state governments according to each state's percentage of the national population. So the states collect the tax according to the state law and remitted to the federal government. The federal government is thus prohibited from involving itself directly in the lives and finances of privileged citizens. This is unique to America, fundamental to keeping power of the hands of we trust the people, and is perhaps the key reason for our economy was second to none during the first century and a half. The 16th Amendment to the Constitution, ratified in 1913, does not address or repeal direct taxes. Instead, it refers to something called incomes. Amendment, I think it's 16. The Congress shall have the power to lay and collect taxes on incomes from whatever source derived, without apportionment among the several states and without regard to any census or enumerations. Incomes under federal tax law lost its common everyday meaning and became a legal term via Revenue Act 1862, which set forth federally licensed trade or occupations, federally employees, dividends from federal investments, and other federally privileged activities, and laid an excise tax on those incomes. Therefore, income under federal tax law is defined as recipients resulting from the exercise of federal privileges. In other words, federal income taxes are taxes on receipts that are taxable, not a tax on all receipts. Again, this is from Lost Horizons. Federal income tax in a nutshell. Visit the website losthorizons.com.